Good morning, honorable members. I hope that we are now all here. We have a very busy schedule today. We have to consider the Public Service Commission Bill, as well as the Water and Sanitation Amended Bill, which will be dealing with our report. Immediate after that, we'll then have a session with the Human Rights Commission to deal with issues raised in our municipalities based in Northwest province. Without any further ado, I'll request Mr. Manele, if we have apologies, to display those apologies that were forwarded to us. Over to you.
Good morning, Chairperson. Thank you, Chair. Chair, from the committee members, we received one apology from Honorable Preet. Besides that, there are no apologies formally tabled to us, Chair. Thank you very much, Chairperson.
Thank you very much, Mr. Manele. Honorable members, for the first session, can we get a mover for the adoption of our agenda? Honorable Berenhorst.
Good morning, Chair. Sorry, my video is giving me issues this morning. I move for the adoption.
Thank you very much. Any seconder?
I rise to second, Chairperson.
Thank you very much, Honorable Chief Whip, Honorable Muimang. The agenda is now duly adopted. We are going to be moving to the first item, but before I do that, let me start by wishing our honorable member, Honorable Berenhorst, a happy belated birthday, which was yesterday. I was fortunate that I was with him in a flight. So on behalf of the committee, I express our wishes, best wishes to him. We wish him everything of the best in life. We hope that you are still wearing your nappies, Honorable Berenhorst. We have not moved them. All the best, and we hope you enjoyed your day.
Okay, thank you very much. Much appreciated. Thank you.
Thank you. We also want to acknowledge the presence of the chairperson of the Public Service Commission, Professor Somadoda Figen, and Commissioner Ashley Say, Commissioner Bacchus, Commissioner Mavuso, and Advocate Makinde, who will also be part of the meeting. And we acknowledge the Acting Director General, Dr. Irene Matenjwa. We also welcome you with your team and feel at home. We acknowledge the apology from the minister who was unable to join us, indicating other prior engagements. Honored members, without any further ado, we'll go straight to the Department and Parliamentary Legal Service written responses to negotiating mandates on Public Service Commission Bill, as well as their observations and what they'll put as legal advice before this committee. Without any further ado, I'll request Advocate Fatima to Ibrahim to take a lead, and we will also be allowing Advocate Makinde on Public Service Commission to also say something on this subject matter. Over to you, Advocate Ibrahim.
Thank you very much, Chairperson, and good morning to yourself and all the honourable members and staff on the platform, as well as our colleagues from the Public Service Commission. Chairperson Advocate Makinde will flight our responses to make things easier for the committee. We captured all of our responses on one document on a matrix, which has columns that indicate the response from the PSC legal services as well as the parliamentary legal services. So Parliament's legal services response is the one that you see in the last column. Chairperson, just by way of background, the committee conducted its own public participation process, as members are aware. The report from that process was shared with all of the relevant provinces, and it would have been taken into consideration at the time that they prepared their mandates. Of course, provinces also conducted their own public participation, and that culminated in the negotiating mandates that we've received over the last 2 weeks. So, Chairperson, I'm going to go through each province separately. I'll start off with the Free State Legislature, and Chair, the order is in no particular order. It's merely as we printed and started going through things, so that the dates may not necessarily align. But I'll start with the Free State Legislature. The Free State Legislature voted in favour of the bill, but they requested that the committee consider the public participation inputs that they had included in their report. And the first of those is an issue concerning the general constitutionality of the bill. And there, the concern was that the Public Service Commission has no constitutional mandate to deal with local government. And they've quoted various constitutional provisions in support thereof. So, Chairperson, you will recall that when I did my presentation in response to our public submissions and our public participation process, I did quite a long presentation on the constitutional issues, and I did indicate that I do have concerns. I also noted that it isn't a clear black and white issue. It is a grey area in law. The Public Service Commission indeed has an opinion from senior counsel, where senior counsel has indicated that they don't have a concern about constitutionality, but I do think that there would be a risk here, and that is for the committee to determine whether the committee is willing to take that risk that the bill may be litigated on once passed, or if it would want to err on the side of caution and remove all references to municipalities and other entities. Of course, that would require a complete rework of the bill. Chair, I'm not going to go through my detailed response on the constitutional matters because it was included in my report. But I will hand over to the PSC also to respond briefly because they have responded to this issue previously, but perhaps they can just say a few words very quickly. Thank you, Chair.
Good morning, Chairperson. It's Commissioner Searle from the Public Service Commission. Chair, before I respond, perhaps just a note of apology from our Chairperson, Professor Somadoda Afekeni. He had planned to join us this morning, Chair, but he's also participating in another engagement that starts at 8:30 in Cape Town. He tried to shift the start time, but unfortunately, the program was very rigid. So apologies on his behalf, Chair. Chair, as Advocate Ibrahim has indicated in our previous session, all of the issues relating to the constitutional matters were also responded to by the Commission. We dealt extensively with our opinion with regards to the submission that Section 196 particularly does not permit the Commission to enter into the sphere of local government. And just for a recap, Chair, the Commission doesn't share that view. In our opinion, a contextual and purposive interpretation of the entire Constitution, not only Chapter 10, but all the surrounding provisions, conclusively leads one to the understanding that the function and powers of the Commission is not ring-fenced and limited to the public service. We've heard during the various submissions that some reliance is placed on Section 196 and reference is made to the utilization of phrases such as public service. And the argument is then that because 196 only refers to public service, the jurisdiction of the commission is somewhat ring-fenced and limited to public service. Our view is completely different and opposite to that, Chair. We submit that it's not only Section 196 that must be analyzed. It is the entire chapter, Chapter 10, which is notably titled Public Administration. And even within Section 196, it doesn't only refer to public service. There's also a few provisions which include public administration. So even within Section 196, that is relied upon by some commentators, within 196, there's also reference to public administration. And as per definition in the bill, and also the accepted understanding of what public administration entails, we are aware that public administration includes all organs of state, including municipalities and state-owned entities, Chair. So that is one submission that we've consistently raised, and we continue to hold that view, Chair. And in addition to that, we've also referred the committee in the last engagement to references to two constitutional court cases where the court had occasion to deal with the issue of Chapter 10. And the analysis from those judgments makes it very clear that the Constitutional Court has said one mustn't be waylaid or misunderstand the utilization of terminology such as public service and public administration when deciding on what the intent and purpose of Chapter 10 is. The court says rather focus on what the true purpose of Chapter 10 is. And the court summarized that to say that the purpose of Chapter 10 is to ensure that there is a constitutional body that is responsible for performing oversight, monitoring, and ensuring that accountability takes place across all spheres of government, not only within the public service, but within every sphere of government. So our submission, Chair, is that, yes, it might be argued that it is a gray area, but in our submission, we contend that it's more black than gray, because the provisions of Chapter 10 particularly does lead to a contention that it is not only public service, but public administration that is the focal point of Chapter 10. We also referenced the specific issues with regards to Section 196(4)(g), and that provision allows Parliament to, by law, extend the powers and functions of the Commission. And we made the submission that if one analyzes the entire Chapter 10 and looks at 196(4)(g), it does allow Parliament to enable the Commission to perform additional functions that are not only limited to what we see in Section 196 for A to F. It's actually broader than that, because if one looks at Section 195 of the Constitution, which deals with the constitutional values and principles, it's very clear that there's a single Public Service Commission, and the Public Service Commission is, amongst others, responsible for promoting the constitutional values and principles across all spheres of government. So if Section 195 gives that responsibility to the Public Service Commission, in our view, by extension, when you deal with additional powers and function that Parliament can assign to us, it must, by its very nature, include those specific issues that are listed in Section 195 of the Constitution. We also submitted other arguments around that, most notably saying that there is nothing within the text of Section 196 which limits the additional powers and functions to those specific areas of 196(4)(a) to F. And in fact, as I've indicated, if one looks at Section 196, it doesn't only refer to public service, but by its very definition, it includes public administration, and we've made the argument as to what public administration entails. So, Chair, in a nutshell, that is our submission on the issue of the constitutionality provisions or concerns that have been raised by various submissions, both during your public participation process, but also during the process with the specific legislatures. So I'll park it at that stage, Chair, because We in this document we have again comprehensively provided you with a response on those issues. And as members will remember, in the previous session we also provided substantial motivation where we differed with the interpretation issue as advanced by the parliamentary legal advisor. So I'm not going to restate what we've already covered in the previous engagements, Chair. Chair, I'll leave it at that. I'm not, if with your indulgence, if there's anything that Advocate Makinde wants to supplement, I'll ask your indulgence to allow her a minute or two just to add. Thank you, Chair.
Commissioner, Advocate Makinde,
Yes,
anything to
Chairperson.
add?
Thank you so much. I just wanted to present this matrix, and I am presenting it for your noting. We have tried to respond and explain the logic and the principles behind everything. And as commissioners still have said, there is nothing much in the responses. 8 provinces have supported the bill. 3 provinces supported in total. Others have made a few comments here and there, which we have tried to clarify. And I think with the issue, the main one is the issue of extension to local government, which commissioners still have addressed. So we are still saying that, you know, if you look at section 196, the essence of the whole of chapter 10 is public administration, which is the presentation we have made earlier. But then this values of section 195 applies to every organs of states, the 3 arms of government and all of that, which is what is here. The resolution of Parliament in 2011 that says we must implement this full mandate, which was the beginning of everything, and we've been going through it till now. So this issue has been discussed extensively, and I think we have come to the agreement that section 196 and section 195 should be read together. There are many clauses in section 196 which talks about the role of the PSC in promoting public administration. For example, if you look at 1962, the commission is independent, must be impartial, must exercise its powers and perform its functions without fear, favor, or prejudice. And I think we've emphasized when it says in the interest of the maintenance of effective and efficient public administration. That is the purpose of the PSC. In the interest of effective and efficient public administration and a high standard of professional ethics in the public service. So we've just mainly reiterated that. So we ask you to note all the submissions that we have made here, just to explain, nothing much, because the bill remains as it is, and we are just explaining. And I think in the public hearing, most people supported this bill. There is nobody in the community that did not understand the fact that there is a need to have oversight and to improve things in local government, and they overwhelmingly support the whole idea. So that is Free State. So we've gone through it province by province. As you will see, Limpopo supports it, Mpumalanga supports it, and then you will also note that Northern Cape supports the bill. In the Northwest, there are a few issues that they have raised, which has to do with qualifications. We've clarified that, the ATS senior management experience, and all the other issues that they have raised there. So it just needed some clarity, which we have already provided also in the public hearing. So this is just a repetition in order to just further put what we have said on record. Going forward, you will also note that the other provinces and the comments that they have made have been taken into account. So noting that all these 8 provinces, they support the bill, you will just note our responses there just for clarity. I'm just going to go straight to Western Cape and the issues that they have raised. In the Western Cape, they went on to say that they do not support the bill in its current form. In other words, they do not totally object the bill, but they do not support in its current form. So the question would be, what are those things that they want us to change? So I will go straight to Western Cape, but as I'm scrolling through just for you to note, we'll deal with the issues of Gauteng here. Basically also just administrative issues which can actually be addressed in the, remember we make rules. Some people say the rules and regulations, it is the government department that make regulations. We are an oversight body that is aligned to Parliament and legislature. Legislature work by rules, and we also work by rules. So the rules are the same as regulations, so we've explained that. And when we are doing this, all the administrative issues, we have our own internal governance rules that will deal with the issues of delegations internally, and now the single public service commission delegate powers among itself. That goes into our governance rules. So we've explained all of that here. And the rules have been there. We've been using it for more than 100 years. This is one of the reasons why we are making this bill to separate us from departments so that there is no mixture. And it's important that we must be seen to be independent and working outside the public service framework, as the case laws have said. So we're going down. Just for your noting, you just note all these responses that we have provided there. And then we go, now I just want to go down, scroll down to Western Cape. This is Western Cape now. Western Cape in itself says the legislature notes that the PSA has a fair amount of discretion to which departments and entities should be subject to inspection and inquiries. It proposes that a clause be inserted to compel PSA to report on same as follows. So we are saying we report as the PSC, naturally, in terms of the Constitution. Inspections are done as part of our routine mandate of the Commission. Investigations happen when there is a reason to investigate, or when we see that there is something going on somewhere, then we go and investigate. It's a fact-finding mission where we do the verification of facts and we issue reports to the relevant departments. And when we issue those reports, we expect the department, when we make a recommendation, to take it seriously and to report back to the PSC how they are implementing those recommendations within a period of 60 days. Or even if we give an advice, they must tell us how they are implementing it so that those advices of a constitutional body are respected and treated seriously. Only if we make it a direction are they required to actually implement it. And if they are not going to implement, then they can then take the matter on review in court. So we explained how we report those that are not compliant and that are difficult, those executive authority. We come to Parliament because Parliament is one of our enforcement bodies, and then we report accordingly. So we explained that to the Western Cape. The legislature also notes that the PSA has a fair amount of discretion as to which grievance should be investigated. And proposes, I'm sorry about that, my voice is a bit down. And proposes that a clause must be inserted as follows. The Commission must report on and keep an official record of all grievances and investigations, which we do. So we are saying public administration must be governed by democratic values and principles enshrined in the Constitution. So those grievance rules we have, and we do. Those grievance rules is where you find the details, the form, the format, how you fill this format, you lodge your grievance, walk-in, written grievances through the anti-corruption hotline. All of that are in our grievance rules. So those rules are already existing and they will continue to improve because they give effect to legislation and make things work smoothly. So we explained that, and then legislature proposed a clause to prevent cadre deployment and the appointment of government officials. So I think that's a political issue. PSC does not play politics, so we do not have anything to say on that, except to say that the process of appointing commissioners is done through the legislature, and it's an open and democratic process where all the members of Parliament, political parties nominate a committee that deals with all of this, and they advertise openly. So those are the issues that Western Cape are raising. The committee also knows the laudable objective of the Commission to be independent and impartial. However, we believe a clause needs to be inserted in Section 14 or alternatively Section 15 that outlines minimum criminal penalties. So we are saying that if somebody commits fraud or has been found wanting of a misconduct, you are automatically disqualified from applying for the post of a commissioner, and also even if you're an employee. So that is what we have put in the bill. But to now say we must monitor how the criminal process works, that would be a little bit outside our scope. We report to the police, that's what we do. And then the police will investigate the case in the normal procedure. So the court and the criminal justice system, the responsibility of the PS is to report a criminal matter to the South African police and other criminal investigators, such as the Directorate for Public Prosecution. The court will then decide on the sentencing in line with the criminal justice system. In terms of fines for those that are obstructing the PSC in the line of his duty, we did propose fines there. So we felt that is adequate and enough in terms of what the bill can cover. So employees' right after a collective bargaining process to approach the Public Service Commission should also be contained. We responded to say collective agreement is monitored by the Labor Relations Act, and that is a matter that is done in the bargaining council. Like in the public service, we have the GPSSBC, we have the PSCBC. That is where the issues of collective bargaining goes to, and it's legislated already. So it does not fall within the mandate of the PSC to deal with collective bargaining issues. So we cannot encroach in that area. So we also ask the members to please note our response to the Eastern Cape. So as it is, it appears that the bill is fine and ready with the support that it has received, and we present it for your adoption. Thank you very much.
Thank you, Advocate Makinde. You have short-circuited the process. If I look at when Advocate Ibrahim introduced the process, was to go through each and every province and give those responses. But in Zulu, Advocate Makinde, in short-circuiting this process, we and the Advocate Makinde. But anyway, I will revert to Advocate Ibrahim to check and ascertain if she's still proceeding with the initial plan. Thank you very much, Advocate Makinde and Commission. Advocate Ibrahim.
Thank you, Chairperson. I'd like to do that just for record purposes, Chair, but we can move fairly quickly on things that we've agreed on. Then it won't be necessary for both of us to raise comments unless the committee would like clarity. So if I could please ask that we go back to page 5 of the matrix, which was the second issue that was raised from the Free State Province, and that has to do with section 15, clause 15 of the bill dealing with the obstruction of the commission. Here, Chair, the submission was that this provision is unlawful because it does not mirror the wording in the Constitution. The Constitution provides that no person or organ of state may interfere with the functioning of the commission. And in the bill, it's drafted as no organ of state may interfere, no person may hinder or obstruct the commission in the exercise of its powers or performance of its functions. And our view here, Chair, was that the term interference would, of course, include hindrance and obstruction. Those are forms of interference. It means not to interfere with the performance of something. So we don't believe it's an extension of that constitutional obligation to not interfere, but rather it is included. So we don't propose either on my side or on the side of the PSC that we require any changes there, Chair. I also have no problem with the fact that it's been made a criminal offence. You'll find that in a number of pieces of legislation, for example, legislation that deals with the public protector would also make things like this a criminal offence. Chair, we can move on to the Limpopo legislature. The delegate there has been instructed to negotiate in favour of the bill, and no comments were made on the bill. Mpumalanga legislature, it's the same. There's been no proposed amendments and they support the bill. Then the Northern Cape legislature also supports and votes in favour of the bill with no further proposals. And then moving on to the Northwest legislature, the legislature votes in favour of the bill, but they have included some comments. Chair, the first two comments relate to clause 4, which deals with the appointment of commissioners. I did note that there seemed to be an error here in that the Northwest legislature may have inadvertently looked at the introduced bill rather than the B version of the bill. So their first comment that we must amend the term recognised bachelor's degree to just any recognised degree. Does not need to change any longer because the B bill already caters to that concern, and the B bill now merely refers to a level 8 NQF qualification. So it doesn't talk about a bachelor's degree anymore. So there's no change that needs to be made there. The next part of the clause was dealing with the years of experience. And in the original bill as introduced, it talked of an 8 to 10 year experience period. And the portfolio committee had amended that to just read 8 years rather than 10 years. And what the legislature is proposing here is that we make it a 10-year period. So in other words, increase that period. That is a policy decision, and the PSC has indicated why they are satisfied with 8 years. That's of no legal consequence. As long as the committee is satisfied that 8 years is a sufficient number of years for the type of experience a commissioner would need to have, then there would be no change that would need to be made there, Chair. Then moving on to clause 13, that's on page 8, if we can just move down. Clause 13, Chair, deals with the implementation of decisions of the Commission. And the legislature here questioned whether these clauses are consistent with the constitutional autonomy of municipalities. And their concern is the fact that in their view, the role of the PSC is a supervisory role and that their powers should not be binding. And their directives should not be binding. And they feel that the PSC is only mandated to advise, investigate, and report. And by allowing the PSC to make these directions, it would mean that you're then encroaching on the autonomy of municipalities. So, Chairperson, this is an issue that I dealt with in the presentation that I made last week, where I did indicate that I do have concerns about the way in which implementation of decisions is dealt with. I am of the view, and I've shared the view, that in my view, it's only a very limited direction that would be binding. Everything else would just have the power of recommendations, and that the PSC cannot make binding remedial action. And the PSC had responded to this in quite some detail as well during our last meeting. I don't know if they want to add anything at this point. But my detailed responses were included in my presentation that was shared in the committee.
Ibrahim,
Yes,
can
Chair?
you repeat the last two sentences? We have lost you.
Apologies, Chair. I said that in my last presentation to the committee, I included quite a bit of detail on this point and the legal arguments as to why I was of the view that these powers to make directives are not binding and that the PSC cannot issue binding remedial action. But the PSC had responded during that meeting, Chairperson, with their counter views as to why they would be empowered to do so. So I don't know, Chair, if they want to add anything at this point. They have put quite a bit of detail in this matrix as well, Chairperson.
Thank you. Maybe before you take leave, Advocate Ibrahim, are there any corrections on this bill which are going to be effected?
Yes, Chair. So, Chair, we've noted that there's one cross-referencing error that must have crept in when we made the changes in the PC. So that obviously has no bearing on content at all. It's just a numbering issue that needs to be corrected. And Advocate Makinde had indicated that there was a spelling error that she had picked up in the schedule. So it's not in the main content of the bill, but in one of the schedules, and that she wanted that corrected. Both of those issues, Chair, it should be no problem for us to merely ask the Bills Office to make those corrections because they're not substantive and they don't change anything in the bill, any meaning. So it wouldn't be necessary then for us to draft a C list in order to do that and send it back to the Portfolio Committee. Obviously, where there are any changes of substance or we move anything around, then that would require us to do a C list that would result in a D bill that would need to go back, be transmitted back to the Portfolio Committee for their consideration and adoption again by the House before it comes back to the NCOP, Chair.
Thank you very much, Advocate Ibrahim. Honourable members, I think the Public Service Commission, Commissioner and Advocate Makinde have given their explanation on the issues raised. It's now your turn if there are questions and comments on what have been presented before us. Let me take hands. Honorable Zimande will be the first one, Honorable Berenhorst second, the third will be Honorable Kaiser, and the fourth will be Honorable Memang. In that order, please. Honorable Skid Kocher will be the fifth. So let's go in that order. Thank you.
No, thanks. Good morning, Chair and the colleagues. I believe, Chair, the intent on the definition of words in particular in the public service and the public administration wouldn't have meant the same thing. And surely the drafters wouldn't have meant that it means the same thing. I hear what Public Service Commission is saying, but isn't not prudent, because this is a matter of constitutional in nature, that the Public Service Commission, in anticipation of future disputes, approach the court for declaratory order in relation to deal with this particular aspect, whether the third sphere of government is also covered to be dealt with by Public Service Commission, because the words used there are clear. So that will also, in my view, assist for capping future costs that may arise out of disputes that may come in future. I know for a fact, Chair, that indeed, unless the matter is of constitutional nature, the court will intervene, but it wouldn't be dealing with bills in general. But if it is a constitutional matter, like it is this one, why are they not considering getting a declaratory order and not only relying on their own interpretation? Thank you.
Thank you. Let's take two members. Honorable Bedenos.
Chair, thank you very much for the opportunity, and thank you for the responses by the department. Chair, I think the response in totality reads like a considered engagement reads less like a considered engagement with provinces and more like an exercise in brushing aside inconvenient inputs. And we saw how quickly this engagement was rushed through this morning. Where real concerns are being reduced to policy matters, and so we've seen that in responses. A lot of the responses refer to policy matters, and I think substance of provincial oversight is effectively being ignored here. So my one question would then be, our first question is, can the department point to a single instance where a provincial concern has led to a substantive amendment or reconsideration in this bill? I also think what we see in the department's response is a pattern where accountability safeguards are proposed. They're dismissing it as policy matters. Where there's transparency required, we're told to rely on internal rules. Internal rules are really difficult for Parliament to do oversight over. And where real risks like political interference are raised, they simply ignore. So the result is that the bill then expands the power of the Public Service Commission, but there's not the necessary checks that you normally would need. And there's no clear reporting obligations, and there's not enough sufficient protection against abuse or selective enforcement. So just a few questions around that, so the imbalance between power and accountability, if I may. Why does the department refuse to include basic transparency safeguards in the bill, specifically a requirement for the Public Service Commission to justify why it investigates some matters and ignores others? Why are critical governance mechanisms being left to internal rules instead of being codified in law, where Parliament can then exercise proper oversight? The Western Cape raises the risk of cadre deployment influencing investigations. Why does the department not engage this concern at all? And what safeguards exist to prevent political interference? And that's the reason why they raised it. How do you justify granting the Public Service Commission wide discretionary powers without corresponding statutory accountability mechanisms to prevent selective or biased enforcement? And there are legal opinions out there already warning about encroachment of municipal autonomy, what concrete provisions in this bill prevents the Public Service Commission from overstepping into executive decision-making at local government level? I think it's really important, Chair, just in conclusion, I mean, what is the purpose of negotiating mandates and the whole process thereof if provincial inputs are neither really meaningfully engaged nor reflected at all in the department's responses? Thank you very much.
Thank you. Let's allow Public Service Commission to respond on those issues, as well as our legal advisor, Advocate Ibrahim.
Chairperson, if I can come in, I can deal with the first question because that is a procedural legal question, and then I'll leave the second question to the Public Service Commission. So the first question was, why don't we simply seek a declarative from the Constitutional Court, given that there is this grey area and disagreement on the constitutionality? So, Chair, the Constitution doesn't provide a process for Parliament to approach a court, and that probably has to do with the separation of powers, because it would mean that every time Parliament is unsure, we would go then to the Constitutional Court and expect them to do the work of Parliament. What the Constitution does allow for, though, is that when a bill is sent to the President after it's been adopted and the President has constitutional concerns, the President may then send that back to Parliament for reconsideration. So the President would then say, I'm concerned about these particular clauses. This is the reason for my concern. Can you please reconsider that? Parliament would then be duty-bound, both houses, to reconsider those matters raised by the President. And if Parliament feels, well, notwithstanding the President's concerns, we're still satisfied that the bill passes constitutional muster, the Constitution then provides that the President may approach the Constitutional Court to refer the bill then and to get clarity. So an example of that would have been the Copyright Amendment Bill and the Performance Protection Amendment Bill, which the President had sent to the Constitutional Court in 2024 because he had concerns over property rights. So that would be the process. At this stage, we wouldn't be able to approach a court for a declarative, Chair. But certainly if the President has concerns, he may send the bill back to Parliament. And then if that still doesn't satisfy the President's concerns, he would then be at liberty to go to the Constitutional Court, Chair. Thank you.
Thank you.
Chair. Thank
Yes,
you, Chair.
you can proceed.
Perhaps I can start with an overview in terms of responding to some of the issues, and I'm certain that either Advocate Makinde or some of my fellow commissioners might want to supplement on some of the issues raised, Chair. Chair, the first issue that I will address relates to the issue of, are we skirting around provincial inputs and concerns that have been raised by provincial legislatures, both here and during the public hearing process? Chair, I don't think that the Commission can be accused of skirting those issues. We've engaged thoroughly. Today, the format of the engagement was for us to respond to particular issues that were raised by provincial legislatures, and that's what we've done. In each particular legislature, those issues have been tabled and we've responded to it. In the verbal responses, yes, you said we short-circuited the process, but we're more than willing to painstakingly go through each and every item that has been raised by provincial legislature and deal with it. It's in the document. We've responded to it in writing, but also during the public participation processes. These are hard and difficult questions that were raised by members of the public and concerned interest groups were also responded to. So I think we've paid tribute to our obligation to deal with these issues effectively and respond to it accordingly, Chair. On the issue of selective enforcement and bias, in my view, even if one looks at the current version of the 1997 Act, one of the obligations on commissioners and the commission as a whole is to serve and honor the obligations of the Constitution. We serve without fear, favor, or prejudice. So irrespective of what issues are raised with us and who is involved in particular issues, that is not a benchmark for the Commission to decide on which particular matters they will engage within. Our decisions on what matters will be inquired into, investigated, inspected, is shaped by what our constitutional mandate is. And that is the guiding yardstick for us, Chairperson, nothing else. So when it comes to making a decision on what we are required to investigate, what we are required to inspect and report on, that is the yardstick, the provisions of Chapter 10, and irrespective of what the particular issues are, that is the areas that we will engage in. I can't think of anything specific that can be leveled at us for selective enforcement and bias. And I think the current version of the bill again entrenches what the Constitution obligates us to do and what the constitutional mandate of the Commission is. And in terms of checks and balances, the Commission reports on an annual basis to the National Assembly, and provincial commissioners will report on an annual basis to the provincial legislature. And in those reports, Chairperson, it will delve into a range of specific issues, including investigations that are done. And if there are any issues with regards to investigations concluded or areas that might be raised about non-investigation of an issue that has been raised with us, that also serves as a platform through which those dialogues and discussions can be held at the National Assembly and also with provincial legislatures. And besides the constitutional obligation to report on an annual basis, all of us engage regularly with legislatures on a variety of issues, whether it is reports that we've concluded on the financial disclosure framework or the financial misconduct framework within a particular province. We report on these issues regularly. So there are platforms and mechanisms currently in place and constitutional mechanisms which allows us to be open and transparent with not only the legislatures, but all interested parties with regards to the work done by the Commission. The issue of cadre deployment, Chair, I'm not sure specifically in what context that is raised, but if one looks at if it is a concern regarding deployment of commissioners that might have political allegiances, as we can see, there's a particular provision in the bill that was inserted by the Portfolio Committee, which specifies that there must be a cooling off period. Now, any individual that has been involved in a political sphere, and that cooling off period is 2 years. And the intention behind that was to ensure that the potential for possible deployment is dealt with in the bill. In addition, commissioners are not appointed in a vacuum. In fact, the legislatures, the provincial legislatures, when it concerns a provincial commissioner, and the National Assembly, when it concerns a national commissioner, plays a key and vital role during the appointment process of commissioners. In fact, that process entails that those committees assess, analyze, and make recommendations with regards to a suitable candidate. The bill, in its current form, replicates those constitutional provisions and ensures that there is a measure of independence by virtue of the involvement of the legislatures in the appointment process. Chair, I'm going to stop at this stage. I'm not sure if there's anything else that my colleague would want to add, either one of the commissioners or Advocate Makinde, on anything specific that I might not have covered. Advocate Makinde, I'll start with you if there's anything
Yes.
specific.
Yes, Commissioner. I just want to
Yes,
say,
I'll request that we become brief because of time constraints, but straight to the point. Thank you very much.
yes, I just want to quickly remind honorable members that this bill was certified by the Chief State Law Advisor. And the essence of certifying it is to ensure that it is aligned to the Constitution. In the process in Parliament, the Chief State Law Advisor participated 100%. They were there throughout all the discussions and they made input. This bill is not only just put together by the Public Service Commission. There is a lot of input that has gone into it. And all of these questions has already been addressed. And that is the response that we have provided, that we have addressed all these issues in the bill as it is already. Secondly, we even went to the extent of obtaining a legal opinion from Advocate Uno Kaitobi, which we have also submitted for the record. So the bill is aligned. We didn't just go with our own interpretation as we feel it is correct. At this stage, there is nothing else we can do. We are not allowed to approach the court for a declaratory order just like that. So we have to go through this process, and that is the way the bill has to be addressed. We have really done everything to seek other opinions, and the bill is constitutional. I will even put on record that looking at the purposive interpretation, even the legal advisor for the Western Cape itself supports this bill, and all provinces, they do support this bill. Thank you.
Thank you very much. I will appeal to the members who are still coming to make their comments that we don't reopen the process. Remember, we had our session with the commissioners and the Public Service Commission and our legal teams. We raised issues and those issues were responded to, including the issues which they've tabled here have been responded to, and provinces have received such responses. So I'm afraid of a situation where we'll start reopening even the initial discussion that we had. So, honourable members, please, let's stick to that principle. The next member is Honourable Ceza.
No, thank you, Chair. This is not to seek to reopen anything. It's just to thank the PSC in terms of their responses. And Chair, you know, if you look at the violations into the 2025 South African Human Rights Commission in the Northwest, and look closely to issues of water and sanitation, issues of electricity supply across municipalities, and the fact that you have a 1 billion scholar transport corruption scandal, in addition to issues pertaining to unjust corruption issues. It just prompts a question to me as to what is it that is an ideal public service administration in terms of what we seek to clarify as a country in light of the violations that have been meted against our people, and in terms of ethics and efficiency, accountability, transparency, and responsiveness to the people. These municipalities and provincial administrators continue. And furthermore, Chairperson, when you look at how many officials of those municipalities across provinces come from the national government, come from here, and therefore the question of capacity becomes quite curious, prompts a question to the Public Service Commission as to how will it be empowered to enforce Section 195's constitutional principles of public administration, particularly in municipalities, where the Auditor General findings reveal persistent MFMA violations, irregular expenditure, and service delivery. what could be the issues that you unravel, unearth in order to, and where are you going to start? Because first, the Northwest, as much as the issues that they are raising are quite important for clarity, is the first culprit in terms of that. There are no municipalities there. We know the situation in Klerksdorp, Ditsobot, and so on, Chair. So I just need to check with the Commission what is an ideal and where is it embedded, an ideal public administration. I'm sure they've responded to this, and I think they should reiterate to cement to us so that even the public is quite aware of what it seeks to do and what effects and outcomes will come out of this timelessly. Thank you, Chair.
Thank you. Honorable Chaza, Honorable Skid Kohan.
Oh, sorry, Chairperson. Let me just open up here. I have just a few questions. I was mainly covered. I just want to understand, and I think that there was one of the presentation that said that they work closely with the SAPS, but I just want to know, like, how do we not criminalize some of these appointments? Let me just, sorry. It says, why does the bill not criminalize like political interference in recruitment? Because that's the core mechanism of cadre deployment. I just want to try and find out to sort of it covers soliciting and extortion of the influence in the appointing process. I just want to clarify on that. And then with the HOD power checks, so the devolution of the concentrates around the human resource power in a single accounting officer. So what built-in checks like external observers on panels, mandatory reasons, publications, or shortlists will prevent this internalized patronage? I think I might have missed that. And then, Chair, actually, the most of it I was then covered through Honorable Bardenos. Thank you very much. Keep to the time.
Thank you. Honorable Memang.
Thank you, Chairperson. Greetings to ourselves, honorable members on the platform, and also the team from the Parliamentary Legal Service and also the PSC legal team. Chair, just two areas. On the issue of municipal autonomy risk, I take comfort. I take comfort from the fact that the Chief State Law Advisor did allay our fears that the bill is constitutional and it meets the constitutional test, and therefore it allays my fear on the concern raised, because the bill definitely will be a good platform to put at the disposal of municipalities the expertise that the PSC has given in relation to the directives to the department, and therefore I'm quite comfortable with the views as expressed by both the PSC and also the Parliament that Section 195 and Section 196 they apply across all spheres because these three spheres they are interdependent. And of course, appreciating the fact that they are also interrelated and also the fact that they are distinct. And therefore, the issue of the constitutional vulnerability, to me, it's an area that obviously it's a cautionary point raised, but I'm of the view that let's support the view as articulated by the PSC, but of course appreciating the fact that Advocate Ibrahim says we need to do that with caution. Chair, the second point relates to the issues around the recommendations and directions. This oversight bodies, not only in relation to Chapter 9, but also Chapter 10 bodies, they are evolving, and an example could also be raised around the public protector, which in more or less was at the same point at some point at some years in relation to its decisions. It took the Supreme Court of Appeal in a matter that involved the SABC for the court to say the recommendations of the public protectors is binding. And if you do not agree with those recommendations, you must then apply for a review in terms of the law. So I'm of the view that the PSC has also reached that point, and this bill comes at the right time, so that we then have the directions of the commission binding, so that we are then able to ensure that they are not ignored, and there has to be consequences if they are ignored. If you don't take them on review, then they must be implemented. So the cautionary words around expanding the directions into General Executive Authority, I don't think we need to worry a lot about that. My view is that what we are trying to avoid is a situation where recommendations of the PSC bills of the PSC are ignored, and there is no consequences for that. So I'm happy, generally, Chairperson, with the thrust of the advice given. And my view is that let's support the views expressed by the PSC and also encouraged by the Office of Parliamentary Legal Service. Thank you, Chair.
Thank you, Chief Whip. Let's then take responses on the other two members' questions. Then we close the matter and we take the voting process of the Select Committee. Thank you.
Thank you, Chairperson. I'll be brief according to your instruction. I'm going to cover one or two issues, and then I am aware that Commissioner Bachus would like to respond to the issue of directions. Advocate Makinde might also just supplement that. But on the question of what is an ideal public administration and what does the Commission perceive such an ideal world to look like? Honorable Teza, I think the answer to that is to be found in Section 195 of the Constitution, which outlines what the basic constitutional values and principles across all spheres of government should be. It speaks about a high degree of accountability, ethical considerations, good governance, listening to our citizens, and responding to our citizens' needs, amongst others. And the example that you raised of challenges in the Northwest can be found in many other jurisdictions across the country. And we as the PSC would want to ensure that within all spheres of government, whether it's local authorities or whether it's state-owned entities, that these constitutional values and principles form the benchmark of what drives all of us as, public office bearers, as public servants, public officials, to actually implement the mandate of either the provincial government or the national government in order to ensure that the lives of our citizens are improved and we honor and commit to what our constitutional obligations are. So without going into a thesis, I would, in summary, say that, that's what we want. And in terms of outcome, with the issues contained in Section 13 with regards to recommendations and directions, it gives us the platform to then ensure that if we deal with non-compliance with regards to, the constitutional values and principles, those recommendation powers, those direction powers, gives us the authority to then have a little bit more bite, and not just have a supplementary power of making recommendations that are willy-nilly treated, by executive authorities and departments, as we unfortunately see. And Honorable Moimang is spot on when he says that the recommendations of the Commission must not only be seen as something that can be treated with kid gloves and be ignored and decided upon whether it's on a whim, whether to agree to it or not. Even our courts are now saying that the recommendations of a constitutional body, and not only the Public Service Commission, but the recommendations of a constitutional body, it holds authority. And an institution that doesn't honor those recommendations and doesn't provide good reasons why they are not going to implement it could be argued to be not complying with the Constitution. And that was one of the judgments that we've seen most recently coming through. Chair, on the question of criminalizing political appointments, I'll ask Advocate McKinley to deal with that. Just on the internal patronage issue, how will this be dealt? Honorable Skeerkogel, in addition to what we have in the bill, there are also other mandates and areas of work that the Commission is currently busy with, most notably the professionalization framework, which was endorsed by Cabinet in 2022. And it gives us as the Commission a particular role, both as an oversight agent, but also an implementer to a certain degree. And as far as the implementing role is concerned, it says to us, Commission, we understand that you can't be involved in the actual appointment of senior officials because, there might be a conflict of interest. But what role we want you to perform is to ensure that there's a measure of accountability and independence that filters through the selection and recruitment process to, amongst others, ensure that issues such as deployment of unsuitable and unskilled individuals can be detected with the involvement of perhaps an expert. So what the framework asks of the Public Service Commission is to actually facilitate the creation of a panel of experts that will, amongst others, assist departments across national, provincial, as well as in the local government sphere, where these experts can actually be utilized during the appointment and recruitment process and play a particular role to ensure that at the end of the day, the most suitable, the most skilled, and the most equipped candidate is eventually who is appointed, rather than other reasons for the appointment of an individual. I'll leave it at that, Chair, in light of the time constraints, and I'll ask Commissioner Bachus to make the input that she wanted to make, with your indulgence, obviously. Thank you, Chair.
Thank you, Commissioner. Let's take Commissioner Parker.
Thank you and good morning, Honorable Chairperson, honorable members, commissioners, and the advocates this morning. Chairperson, I'm just going to make 4 very quick points. One, to start off by saying that if the directives of the Public Service Commission are merely discretionary, the Commission would obviously going to be reduced to an advisory body without any meaningful remedial authority. So as a country, we already accept the enforceable remedial powers from institutions as a precedent, such as the AG of South Africa, including at municipal level. So the same principle of strengthening accountability should apply here. We have that precedent already. The second point is what the bill actually seeks to do is simply ensure that those constitutional principles are upheld consistently across the entire state, across all 3 spheres of government. So municipalities will still retain their executive authority, but accountability for ethical and professional administration must apply uniformly to all spheres of government. At the SALGA convention held in December 2025 at the ICC in Durban, the Deputy President and Honorable Minister Hlabisa called for the support of the bill in its current form. I need to make that point. Insofar as criminalizing the cadre deployment, I think, a lot of the times the public protector deals with the criminal actions. We mostly deal with the administrative actions. And, I have to make the point also, Honorable Chairperson, honorable members, we do not have powers over the executive. We only deal with administrative issues. What we can do, though, is we can help to build the HR checks and balances based on our powers in the Constitution that speak to recruitment, selection, etc. in Chapter 10. We do write guidebooks and manuals, which we've done for provincial and national government, to help professionalize the public service, and of course, to enforce and entrench ethics and integrity. So in fact, in our stakeholder consultation process, honorable members, with municipal structures, labor organizations, municipalities themselves directly, which we went through an extensive process last year. A lot of the municipalities, major ones and even metros, called on us to help them to deal with the interference with the administration and to deal with the administrative executive divide. Thank you. I will rest my comments there, Honorable Chairperson.
Thank you. Advocate, anything to add?
Just to say that the commissioners have said everything. I think the main thing, which is the one question that is, what would the PSC want to see? For us, is mostly that principle of the constitutional values. It must be adhered to across the board. So we want to see that consistent application. We want that accountability to be improved, and we want that professionalization to extend to the 3 spheres of government so that there is improved service delivery. Furthermore, on this issue of cadre deployment, irregular appointment is taken very seriously by the PSC. We've issued many manuals on that, and we are going to improve to make sure that there is minimal political interference, and where that is established, it becomes an irregular appointment, and that will have to be taken on review. So I think we've been doing a lot of work on that. And this issue of establishing the panel of experts is what we are also working on to make sure that those HODs and all high-level positions, we will deploy panel of experts into those panels to make sure that the process is correct and those irregular appointments are avoided as much as possible. Thank you.
Thank you very much for all the responses. They were very clear. Honourable members, you'll recall that in our previous meeting, we dealt with provincial mandates. Out of 9 provinces, 8 provinces supported this bill without any amendments after deliberation, the stakeholders and the provincial public hearings. So now I'm putting it to you. I know that you are not allowed to contradict your provincial mandate, but for the purposes of records, we need to accept what has been submitted before us by the Public Service Commission, the department, as well as our legal advisory office. So now we want to get from you if we support Honorable Mumang moving that let's adopt this report, these responses, as part of our consideration, as we'll be making our propositions to the NCOP for the approval of this bill. Let me get your confirmation by province. Let's start with Western Cape. Honorable Badenhorst.
Honorable Chair, thank you very much. In line of the mandate from my province, we will not support this report because we don't support the bill. Thank you.
Thank you. Honorable Skirkoher, Free State.
Thank you, Chairperson. Based on what my province has said, they do support the bill.
Thank you. Honorable Kaiza.
Thank you very much, Chair. In line with my province of the Rising Sun, Mpumalanga, support the bill.
Thank you. Honorable Muimang, Northern Cape.
Honorable Chairperson, as it was indicated, the province of the Northern Cape support the bill. So therefore, I align myself with the responses as put forward. Thank you. In support of the bill.
Thank you very much. Northwest, Honorable Mabibo.
Thank you very much, Honorable Chairperson. The Northwest support the bill. Thank you.
Thank you. Honorable Moloko, Limpopo.
Thank you, Chair. In line with the mandate from my province, I support the bill. Thank you.
Thank you. Thank Honorable Zimande.
Thanks, Chair. Yeah, Gauteng support the bill with the provisos submitted on the mandate. Thank you.
Thank you. Which other province, because Honorable Peter is not here, KwaZulu-Natal, support the bill and also support the responses that have been given as the way forward for the adoption of this amendment bill. That is KZN. Is there any province that I've left out? I think it's only Eastern Cape, ne?
Yes, Chair.
Yeah, so we take it that Eastern Cape, they supported the bill. Thank you very much. That concludes our deliberation on the Public Service Commission Amendment Bill. And we want to thank the team, the commissioners, the advocates for the work that they've been doing in putting all this thing together. And we thank the department, acting DG. We thank you and your team for having considered and also dealt with preparations before this body. So with that, this closes this item. Thank you very much for your participation. We are now moving to the second item on the South African National Water Resource Infrastructure Agency, SOC Limited Amendment Bill, B13B of 2025. Honourable members will recall we dealt with this. The department came before us, they responded, and stakeholders presented, the clerks foundation also, we dealt with their submission. Now it's our turn to adopt our report, which need to be presented to the NCOP plenary. We have submitted this report to you so that you consider it. It just deals with what the background deals with what is before us, which was Section 75, which did not require any provincial public hearings, the objects of the bill, and we dealt with that, and as well as the commentary in terms of the bill. And we are saying to this report, there are no material issues that will require any changes, as well as we are supporting this without any amendments. So let me welcome members, your comment on this report. If you see anything that you want to correct, but also the content in terms of our deliberations, so that we can just adopt this report and move to the next session. Can I take hands indicating what is your view on this? What is your take as members of this committee and the provinces? So can I start with Western Cape?
Western Cape will support you.
Thank you very much. Let's then take Free State on our scale Quaker.
Thank you, Chair. Free State will support.
Thank you. Let's take Mpumalanga. Honorable Ceza.
Mpumalanga will support.
Yeah, you must mention Mpumalanga as your premium. Mpumalanga. Then let's take Northern Cape.
Thank you, Chairperson. Thank you, Honorable Chairperson, for the opportunity. Chair, the Northern Cape informed by its appreciation that the bill was, is technical in nature, and that it was only meant to make provision for the listing of the agency as a major public entity in Schedule 2 to the Public Finance Management Act, and also to provide for the delisting of the Trans-Caledon Tunnel Authority from Schedule 2 to the Public Finance Management Act, and to provide for matters connected thereof. Therefore, I support the report. Thank you.
Thank you, Honorable Mang. Our whip of the committee, Limpopo, Honorable Molokome.
Thank you, Chairperson. Limpopo supports.
Thank you. Honorable Mabibo, Northwest.
Thank you, Chairperson. Am I audible?
Yes, you are.
Yes. Bokoni Bupirima support.
Thank you very much. Let's then take Gauteng.
Gauteng support you.
Amapanya support. Amapanya honorable. Amapanya. Okay, now let's then take KwaZulu Natal. We have considered all the facts that were put before us, and we are in full support of this bill for its adoption. Then Eastern Cape, Honorable Peter has apologized, is not here. We will have to proceed with the voting before this meeting so that we process these issues. Thank you very much, honored members, for your own support and voting of the process. We are indeed now going to be entering into another session. Don't check out of this platform. Remain in the platform. You must drink water for now. Exactly at 10 o'clock, we'll reconvene. But with the Public Service Commission, then on Wednesday, we'll deal with the final mandates of provinces. Just to be certain that after they've received every response, what is their final mandates. So we'll process that on Wednesday next week. Thank you. If members, that concludes, if we accept all this concludes our first session. We're now going to be entering into the second session of our meeting, where we'll be meeting with the Public Human Rights Commission, and as well as Matibeng and Kehleng municipality, whom we visited before. We said to those municipalities that we have already visited, when this report is presented before us, at least we should have them so that we can also follow up on any matter that you would like to follow up. Thank you very much. Let's then wait for 10 o'clock so that everybody joins for the second session. It's now 2 minutes to 10. Thank you.
It's Matibeng and which one, Chair?